and I will be your moderator for today's event. Our presentation will last approximately 40 minutes, with the remaining time available for your questions. Earlier this morning, we emailed you a link to a copy of our presentation. Hopefully you got that in your email. If you haven't, feel free to email me right now at julie@enlightenbiz.com. That's julie@enlightenbiz.com, and I'll send you that document right away. It's helpful when you want to take notes or if you want to get the speaker information that we have included in there. Before we get started, please note that this webinar and all of the accompanying materials are protected by copyright and that the entire presentation is being recorded. This presentation provides general information only and does not constitute legal advice. We certainly recommend that you consult with your legal counsel to address your specific situation. So we're also looking for webinar topics, and you see my email address right there on the screen right now. We'd certainly welcome you also sending in any topics that you would like us to cover or explore for future webinars. So let's get started today by welcoming our expert panel. First, we have Linda Duffy. Linda's president of Ethos Human Capital Solutions. Linda works with business owners and executives to provide strategic human resources direction, develop leadership talent, and increase organizational effectiveness. We also have on our expert panel attorney Marla Mehrab Robinson. Marla is with the law firm Mehrab Robinson, Jackson, and Clarkson. Hold on, we have a little bit of a technical problem. There we go. Hopefully, Linda, you can continue moving those slides. To Marla's bio, thank you. Marla, again, is with the law firm Mehrab Robinson, Jackson, and Clarkson, where she is a partner and head of the firm's transactional department. She primarily practices in the areas of corporate, mergers and acquisitions, real estate, finance, and employment law. We have a great panel today, and we certainly encourage you to include questions. There's, of course, a sidebar over on the right-hand side where you can enter those questions either via questions, the questions tab, or chat, so feel free to add those in. And Linda, I'm going to turn it over to you so we can get started.
All right, Julie, thanks so much, and thanks everyone for joining us today. As some of you might know, and we're probably on the webinar a couple months ago, Marla and I did a webinar on sort of like the big leaves of absence laws. And sort of the bad news, I guess, for those of us in the state of California, if you have over 50 employees, you have something like 22 different leaves of absence laws that you have to be in compliance with, whether they're at the federal level or at the state level. So 2 months ago, we actually did a leave of absence on sort of the big five, if you will, the ones that I'm showing on the slide right now. And if you missed it for some reason and you want to go back and watch the webinar, watch the slides and listen to it, I'm providing you a link right there that you can go to. Or if you just want to download the slides or both, there's a link as well that you can go and download those slides so you'll be up to speed on those laws as well. So today, we're really talking about the other 17 leaves that you may be subject to. And we've tried to make it really simple for you by putting together sort of a chart for each one of the leaves talking about some of the main issues. But hopefully you've already downloaded the slides and you can just add any sort of comments you have. And then as Julie mentioned, we're happy to address any specific questions that you have when we get done with the presentation. So the first leave of absence that I'm going to talk about is jury duty. And again, today's leaves are pretty straightforward for the most part. This is going to apply to all employers regardless of the number of employees that you have. So even if you just have one employee, you are required to let them take a leave of absence in order to perform jury duty. So obviously the eligibility standards, just to go through this first chart, the coverage is for all employers. To be eligible, the employee had to have been subpoenaed to appear as a juror. The qualifying event is a subpoena usually. And the length of the leave available is whatever the jury duty required. So they could get called and never have to show up. They could get called to jury duty and show up for 1 day, or they may get fitted on a trial that could last a year. You have no idea when they go in. So whatever that jury duty is, that's the length of the leave of absence you're required under the law to give them. Once the jury duty has ended, you are required to reinstate them to their position. And of course, they are required to give you advance notice because they will have had advance notice as well. This is actually part of the California Labor Code. And just so you know also, sometimes we get questions about what about PTO? Does it have to be paid or unpaid? Can they take PTO? Can we require them to use PTO? Jury duty does not have to be paid by the employer. You just have to simply provide the time off. There's no direction in the Labor Code section with regard to the use of PTO. So Marla and I, when we talked about this webinar and we went over some of these leaves, our advice to you is don't require them to use it if there's no direction on the use of whether or not they can take vacation, not take vacation, whatever. Don't require them, but most companies would allow them to use their paid time off or vacation benefit for such a leave, in my opinion. Now, keep in mind one other thing about a lot of these leaves that we're going to talk about, especially the ones I'm going to talk about, is there is going to be a difference in how you treat your hourly or non-exempt employees from how you treat your salaried or exempt employees. The difference is that if an exempt employee does any work during that work week, you really are paying them a salary. So it doesn't matter if it takes them 1 minute to do their job or takes them 100 hours during the week, you're still going to pay them their full salary. That doesn't change if they've had jury duty. If somebody's out for the entire week on jury duty and they're not checking emails or returning phone calls or doing anything, then by all means you don't have to pay them. But that's usually not what happens, right? For those of us that are salary exempt people, a lot of times we'll be checking emails on breaks, we'll be doing work at night, whatever it is. And if your exempt employees are doing any work during the work week, you need to pay them their full salary regardless of the time that they're missing due to jury duty. We do have a memo on salaried exempt employees and deductions you can make from their pay, because we did have this as a webinar topic last summer. So if you're interested in that, just shoot me an email and we'll make sure that gets out to you as well. As with most of these, there are specific prohibitions against employers from discharging, discriminating against, or retaliating against employees for utilizing their jury duty right or benefit. Witness duty is the second one, and pretty much it's the exact same thing. So this comes into play if somebody gets subpoenaed to testify in court as a witness to a crime. Same thing, it's going to cover all employers. There's going to be a subpoena, so they're going to give you notice. However long it takes is how long it takes, and they are legally entitled to be reinstated to their position once the witness duty is over. And just like with jury duty, you have the same prohibition against discharge, discrimination, or retaliation, and it does not need to be paid. And again, there's no direction on the use of PTO for this as well. It's actually a different subsection of the same Section 230 of the Labor Code if you want to go and read up on that for yourself. The next leave of absence is for crime victims. So in this case, it'd be something that happens to you. You're a victim of crime, you get subpoenaed, you're going to go to court or attend judicial proceedings related to that crime. You are entitled to go do that. If you can give advance notice, then you are required to do that if you're the employee. And as an employer, you are required to reinstate the person to their previous job. The victim in this actually means certain felonies that are violent or serious felonies, or in a felony involving theft or embezzlement, and that's defined in the Penal Code. This particular law does provide that employees may use accrued vacation or personal leave time, sick leave, comp time, unpaid leave time, whatever they want, so they don't have a loss in pay. The other thing about this particular crime victim leave of absence, which you'll also hear us talk about on some of the other ones, is the employer has a specific requirement to keep the employee's absence, or the reason for the absence, I should say, confidential. So you cannot go out to your employees and say, hey, so-and-so is a victim of a crime and that's why they're not here today, they're in court. Most likely, the employee is going to tell everybody, but that's something that you should leave for them to do, and certainly not violate that confidence from a company point of view. The next one is victims of domestic violence. This one actually implies only to employers, well, all employers have certain requirements, and then employers, if you have 25 or more employees, you have additional obligations. And I'm going to tell you what those are in just 1 second. So any employee that's a victim of domestic violence can take time off that's necessary to resolve those issues. So it could be to appear in court. Again, they're probably with a subpoena. They may have to go to court to get some sort of judicial relief, like maybe a temporary restraining order or something like that, in order to ensure the health, safety, or welfare of themselves or children. And if that's the case, they need to be able to take that time off. For those of you that have 25 or more employees, then you also have it also prohibits action against that employer for taking time off to seek medical attention. So it's a little bit further than just taking time off to go to court. This actually says they need time off to seek medical attention, which may be psychological counseling or medical, seeing a doctor, or to obtain resources from a domestic violence program, any of those type of things. So if you have 25 or more, you also have to give them time off to do some of those ancillary activities. And keep in mind also, if they do need to seek medical attention for themselves and you have more than 50 employees, then you also are going to be subject to FMLA and CFRA as well. So we talked about those again a couple months ago, but just keep in mind if you have 50 or more, once we're talking about anybody that has a medical condition, you may have additional obligations beyond just what this law provides. This law also specifically says that an employee can provide certification of a court appearance after the fact. So yes, you can ask for advance notice if it's feasible. They should provide it. But there may be some instances where they have to go to court and then after the fact provide you with documentation that they were actually in court. And you should not take any sort of action against that employee up front until you give them the opportunity to actually get that certification. Just like with the last leave I talked about, the employer must keep the reason for the absence confidential. And unless a collective bargaining agreement says otherwise, the employee may use vacation, personal time, comp time, or anything else to pay themselves essentially while they are taking time off to resolve any of the issues around their domestic violence. Next one is victims of sexual assault. Pretty much exactly the same as the last one. Again, it's a different subsection of the same law. So anybody who's been a victim of sexual assault can take time off to resolve that issue. And again, the time off requirement is for all employers. And then if you have 25 or more employees, you have the additional obligations in terms of seeking medical treatment, psychological counseling, those types of things. Time off to vote. So this was sort of interesting because I actually learned something on this. Marla and I were talking about this when we were preparing for the webinar. I always knew about the requirement to give people time off to vote. Honestly, in almost 30 years of doing this, I've never had to give employees time off to vote because I've never had anybody work a schedule that would prohibit them from either voting before or after work or during lunch or something. But hypothetically, you could have a situation, maybe you've got an alternative work week that has some strange schedule, like they're working 12 hours, 7:30 to 7:30, and you have an employee that lives more than a half-hour drive away, so they can't, the polls open at 7 and close at 8, and they can't, do it before work or after work or go on their lunch hour or whatever. So this is actually set up to allow employees who are unable to work or unable to vote, rather, due to their work schedules, to take the necessary time off to vote if there's a statewide election. They should give you notice, at least 2 days notice. But what I didn't know, so I just want to point this out to everybody, is if they need to take time off to vote, and because of their schedule, that the employer is actually required to pay them up to 2 hours of time off. That was the part I didn't know, to be honest with you. If it's more than that, if there's additional time off, that can be unpaid, but the first 2 hours actually need to be paid by the employer. So that was news to me. So again, hopefully nobody has this situation come up. The other thing to keep in mind is that the time off can be provided either at the beginning of the shift or at the end of the shift, depending on which will allow the employee time to vote. If there's a different time, then by mutual agreement, the employer can negotiate a time if they're going to take a long lunch or something other than the beginning and the end of the shift. The other thing to remember about time off to vote, which is different from most of these leave laws, this actually has a posting requirement that goes along with it. So you are required to actually put a poster up at least 10 days before every statewide election that needs to stay up through the election date, notifying employees of their right to take time off to vote. And those are easily downloadable off of a website. It's really just a flyer almost more than anything else. All right, organ and bone marrow donation. This is one of the newer laws, actually just came out probably about 4 or 5 years ago. So if you have 15 or more employees, you are required to give employees time off in order to donate an organ or to donate bone marrow due to medical necessity. The length of the leave is actually up to 30 days per year if you're donating an organ and 5 days if you're donating bone marrow. You are required to give the employee the time off and also to reinstate them to their prior positions. These leaves are actually paid leaves. I don't know if there's any other leave we're going to talk about today that requires the employer to actually pay this leave. The employer can require that the employee take up to 2 weeks of sick or vacation leave for organ donation and up to 5 days for bone marrow donation. So just keep that in mind as well. And then the employee will, of course, provide you written verification of being a donor and that it's medically necessary. The other thing to know about this is that the leave may be taken in one or more periods during the year. So it's not where you can require them necessarily to take like all 30 days at the same time. The leave of absence cannot be considered a break in service, so you cannot say, okay, well, while you're off on this leave donating an organ, you're not going to accrue vacation, or we're going to cancel your insurance, or it's going to postpone a merit increase or anything like that. You have to treat it as though they just continue to be employed during that time. And the other rule about these particular leaves are that the time off does not count against FMLA or CFRA. So again, if you have 50 or more employees, this time off would be in addition to the 12 weeks that they're allowed under FMLA and CFRA. The next one is the California Alcohol and Drug Rehabilitation Act. This applies to any employer that has 25 or more employees. And it basically is a situation where an employee comes to you to say, hey, I've got a drug or alcohol problem, and I want to voluntarily enroll myself in a rehab program. You would be required to give them the time off unless you can show that it's an undue hardship on the business, and then afterwards reinstate them to their prior position. What it does not do is prohibit you from either refusing to hire someone or discharging an employee if they have a current use of alcohol or drug that prevents them from performing their duties or, in a manner that would possibly endanger others. So with this one, it really is dictated by, who goes to whom first. If you have an employee that comes to you to say, hey, you don't know this employer, that I have a drug or alcohol problem and I want to go into rehab, then you're required to work with them on that and accommodate them as possible. If you find out that the person has a problem, they're showing up to work drunk, they're missing time, whatever, and you determine it's a drug or alcohol problem, then you can certainly address it as you would any other disciplinary issue, and under at-will doctrine anyway, do anything up to and including terminating them. So you just want to make sure that you're not retaliating against them or discharging them for coming to you and seeking help for the problem. But again, if they're not performing their duties and it's due to drug or alcohol, you do have the right to take action at that point. The employee is allowed to use sick time while they are in this rehab program. And if, again, you have more than 50 employees, remember you're going to have additional obligations under FMLA, CFRA. You might want to talk to legal counsel about how the interplay is going to work with those, or FEHA as well. So just make sure that you're looking at everything correctly. The last one I'm going to talk about before turning it over to Marla is kin care, which is essentially a leave to provide somebody with sick leave to attend to a family member. So this only applies to employers who provide a sick leave benefit. So for those of you that don't, you don't have to worry about it. If you provide PTO, however, and one of the reasons for PTO is that they can take it when they're sick, then this would apply to you as well. So don't think just by labeling it PTO, you get out of that, because it will cover those employers as well. So this basically says that employers must allow employees to use a portion of their accrued and available sick leave benefits to care for an ill child, whether the child is biological, foster, adopted, a stepchild, a legal ward, a child of a domestic partner. It does not matter. A child's a child. A parent, a spouse or domestic partner, and you are required to give them, allow them to use up to half of their annual sick benefit for that purpose. Now, you can allow them to use any, all of it if you want to. You can, let's say, if you give them, 6 days of sick leave a year, you could say you can use up to 3 to care for somebody else, but you have to hold off 3 for your own sickness, something like that. Marla's going to jump on the call now as well because we've been talking back and forth about the benefits of having a PTO policy versus a sick, splitting out sick and vacation. So we're just going to do a little pro and con argument for you right here. So one of the things that I always tell my clients when we talk about this, I was just having this conversation yesterday as I'm dropping a hands up for somebody. They split out their vacation and sick separately, and they also even have what they're calling floating holidays, let's say. So they give basically 2 weeks of vacation each year to people, another 5 days of sick. It's on a use it or lose it situation at the end of the year, and then they also have these 3 floating holidays. And I said to them, while I understand it's accrued liability that you have to pay off if you combine it all into PTO, I think it does help with administration, and it does help cut down on all of sort of the, weird absences you get toward the end of the year. So with this particular client, we're looking into what their attendance is like in December, because if they're giving employees 5 days at the beginning of the year and saying if you don't use them by the end of December, you're going to lose them, guess what's going to happen? My belief is they probably have a whole bunch of people all of a sudden calling in sick on, in December and doing some Christmas shopping because they know that they're going to lose the time at the end of the month. So I usually push my clients toward the PTO side unless they have a really strong opinion otherwise, or they just don't want to take the risk on paying out the sick pay upon termination. Marla, are you on the call yet?
I am.
So go ahead and jump in, and you can do the con on the PTO side.
Oh, I don't know that it's such a con. It's just something to look at because, I'm always of the position that we need to look at each company individually and what their culture is like. And Linda and I were discussing this. I just know that some companies are more concerned about the kin care. The kin care is only available if you have sick leave. However, if you have PTO, that's going to be considered sick leave. So if, let's say you have 10 days of PTO, you don't know whether they're taking that off for personal reasons or for sick leave or for the kin care. Of course, if they tell you, you do. But I would rather have the ability to identify, okay, this was time taken off for kin care, and that's all you get. 3 days is what we have for sick leave policy, or 5 days. There's no more for taking off to leave for a family member. Now, this really helps, I think, smaller companies more than big companies because there's more potential for abuse to take off for that. There is obviously, as Linda pointed out, the abuse of, okay, it's December and I've got 3 days sick leave, but I didn't take them, I better take them now. But I think that's very suspect, and that can bring about warnings and concern and visits with the HR department. If this is an issue, this is going to be suspect if it happens again. PTO, like vacation, the pro of this that Linda didn't mention that I will mention is it's still subject to the employer's approval, unless the employee comes to you and says, no, wait a minute, it's for kin care. So that was the big difference. As with kin care, they have to be able to show you that this is what it's for, and to get that approval. But if it's PTO, that's not necessarily the case. If they say it's for kin care, then it's for kin care. So hopefully that didn't thoroughly confuse everyone, but there are choices there, and in each company it's different. So the first, what I'm going to talk about is time off to visit school authorities. So we're still kind of in the family mode here. And this applies to all employers, and all employees are eligible. And it protects employees who must miss work to attend parent-teacher conferences. And these are not just conferences to see how the child is doing. This particular statute, Labor Code Section 230.7, for those of you who like to read statutes, is for conferences due to suspension of the child. And there's a specific requirement under the Education Code that requires schools to bring parents of suspended children in for a conference. And so this allows the parents to take that time off and prohibits the employer from discharging and disciplining. And if the employer does engage in unlawful conduct, it allows for reinstatement and reimbursement. for both lost wages and benefits. The next leave I'm going to talk about is the Family School Partnership Act. Again, we're still in family mode here. However, this one doesn't require suspension. This is for employers of 25 employees at the same location. So it's not just 25 employees, any location. You have to have 25 employees at the same location for this to apply. And it's for employees with children or custody of children in daycare, kindergarten, or grades 1 through 12. So basically from birth through 12, through grade 12. I'm not sure why they call it out that way. Again, for the statute lovers, it's Labor Code Section 230.8, so you can see it's in the same section, just a different subsection. This is for participation by a parent in any school or child care day activities. So for those of us with children, you know, it's the plays, it's the Mother's Day lunches, the Father's Day breakfast, those types of things. And it's up to 8 hours per month and 40 hours per year, which to me seems very substantial. An employer can require the employee to provide documentation. In the unusual event that both parents work at the same employer, only the first parent to give notice may attend. Of course, the second parent can attend if the employer allows it. You can always give more than the statute requires. It does have reinstatement rights. Again, the advance notice is required. There are strong penalties on this one as well for unlawful conduct by the employer, up to 3 times lost wages and benefits if the employer disciplines, discharges, or retaliates against the employee. Hopefully with this language you'll see, and if you do read any one of these statutes, you'll see this similar language. I don't even call these leave of absence statutes. They're really more discrimination statutes because it's about not discriminating against the employee, not taking action against them. You might be an employer who's allowed the leave and then terminated the employee after several of these leaves or one of these leaves, and the employee has a claim. You didn't terminate me for the reasons given, or maybe there were none given. You terminated me because I took that leave and you were not happy about that leave. So the next one is the Employee Literacy Education Assistance Act leave. And this is for employers with 25 or more employees in any locations. And employees who are eligible are those who enroll in Adult Literacy Education Assistance Program. I have never had this leave come into play. It's in Labor Code Section 1040 through 1044. It's a very brief code section. If anybody has had this come up, I would love it if during the question and answer period you would tell us about it. I would like to know, because as I said, I've never had it come up, and I think Linda confirms she's never had it come up. It requires employers to reasonably accommodate and assist an employee who reveals problems with illiteracy and requests assistance. And the specific assistance that they request is in enrolling in an adult literacy education program. But the key here, like our FEHA requirements is, and ADA, is reasonably accommodate. It's an undefined term and won't be the same for every employer. So we need to look at this on a case-by-case basis if it does come up. The statute does say that employer assistance includes, but is not limited to, providing information to the employee of locations of local literacy programs, arranging for a literacy education provider to visit the job site, which is odd because like some of the statutes that Linda discussed, this one also has you must keep the fact that there is a literacy here confidential, which is hard to do when you have somebody visiting your job site when everyone wants to know who that is, and it's an education provider. I'm sure most employers don't know where the local literacy programs are. This seems to put an affirmative duty on them to find out when the employee asks for this. It does not require the employer to provide time off with pay. In fact, time off may not be reasonable. Again, that's going to be on a case-by-case basis. We're going to have to look at it if that's reasonable for the employer. And that will bring into play the questions of undue hardship that we've talked about before in our prior webinar on the more difficult leaves. So the next one is the U.S. Military Leaves Law. And this is really not called the U.S. Military Leaves Law. It's the Uniformed Services Employment and Reemployment Rights Act, USERRA, and that's at 38 U.S. Code 4301, excuse me, to start at SEC. And it guarantees time off. It applies to all employers, and all employees who enlist in military services or who perform military duties or reserve duties. Again, this is really an anti-discrimination act because it's not just the leave entitlement, it's whether you take any action against this employee, demotions, moving them to different positions, because this particular act says that the employee has the ability to take a statutory maximum of up to 5 years of leave to be performing duties in the services. And at that time, they still are entitled to any promotions, pay, and the like that they would have received had they not taken the leave. So it's very generous, in my opinion, rightfully so. But if you do have someone who is enlisted in any of the military services and comes to you for this type of leave, I would recommend that you get the assistance of an attorney, because this particular law is very convoluted in what they're entitled to and should be looked at on a case-by-case basis. Also, as to qualifying events, they need to give you advance notice, and they usually have advance notice when they've been called up. And of course, their reinstatement rights are guaranteed. Now, as is very often the case in many areas of California employment law, California has decided to give more protections, even with the broad protections given in the federal law that we just touched on. The California law, which is found in the Military and Veterans Code, Section 394 through 395, also prohibits discrimination against any officer, warrant officer, or enlisted member of the military or naval forces. But it has some additional protections up to 52 weeks for disabled military personnel. If they're disabled while on leave, they get additional time off. Again, this applies to all employers, and it's not just members of what you might consider the regular military services, but also reserves, the guards. The length of leave here is listed on the slide is a little confusing and incorrect. This is really more for the training part, 17 days for private employers and 180 days for public employers. It's actually beyond that, depending on the type of service and what their leave requested. This is another one. If you get the call for this, call an attorney and have them go through both the federal and the California. It's a little bit like FMLA and CFRA. There's some minor crossovers. The next leave is spousal military leave. Linda calls it the sex statute. We want to encourage our military to continue to have sex with their spouse. So this is covered for employers with 25 or more employees, and the eligibility is to just be a spouse of a qualified member of the Armed Forces, National Guard, or Reserves. The qualifying events are just if your spouse that is in the forces has qualified time off, and you have the right to up to 10 days leave during that qualified leave period. With reinstatement rights, you are supposed to give 2 business days advance notice. This is found in Military and Veterans Code Section 395.10. And to define a qualified employee, you have to have 4 criteria met. You have to be the spouse of the qualified person. You have to work 20+ hours or more per week, so a little bit more than part-time, or part-time a little bit. You have to notify the employer within 2 days of receiving official notice, as I said earlier, and then you have to submit written documentation certifying that your spouse will be on leave. The spouse of that is in the service usually receives written orders, so that's what you usually receive as the employer. So the next one is the Civil Air Patrol Employment Protection Act, and like Linda, I'm going to admit, after not nearly as long years of practice as her, 26 years of practice, I've never heard of this one until we decided to do this webinar. And again, would like to ask if anyone has had this leave request, please share it with us, because I'd love to hear about it and what happened. It applies to all employers with 16+ employees. So 16 is the magic number here. It's a number I've not heard in any other employment law statute, so it's odd in that respect as well. And it is for employees who are volunteer members of the California wing of the Civil Air Patrol. I have never met anybody who is a member of that patrol, so maybe that's why I wasn't aware of the act either. if they're directed to respond to an emergency operational mission, then they're entitled to leave, and it's up to 10 days. Their reinstatement rights are guaranteed, same or equivalent position. And the only notice they have to give as much as possible because, again, we're talking about emergency operations, and sometimes there is no notice available. And also, again, prohibits discrimination and retaliation as the others do. The next one everyone's probably familiar with. I think this one comes up quite a bit. I know a lot of employers have volunteer firefighters in their employment. And this applies to all employers, but then it has an additional requirement for employers who have 50 or more employees. Just puts additional obligations on them. And all employees are eligible. The qualifying event is emergency firefighting duty, or we'll have seen a little bit also to some training. And the time and length of leave is the time necessary for the emergency duty. They do have reinstatement rights. And advance notice requirements, the statute is silent. It's California Labor Code Section 230.3. All employers are prohibited from discharging or discriminating against an employee for taking time off to perform these emergency duties as a volunteer firefighter. However, the additional obligations for the employers with 50 or more employees is that they must provide temporary leaves up to 14 days per calendar year for the purpose of engaging in fire or law enforcement training. So when the duties of emergency duties are for all employers, and the training is for those employers of 50 or more. And then, of course, there's leaves that are not statutorily mandated. The most common is bereavement leave. And when considering whether to adopt a bereavement leave policy, the first thing you need to consider is who qualifies for leave. Is it all employees? Is it employees who've been with us 30 days, 60 days, 90 days, sometimes called an introductory period? Is it office staff but not warehouse staff? Be very careful when you start discriminating to make sure that you're not discriminating based on protected classes, but discriminating based on some other factor. But that would be the first item to look at. The next is whose deaths are covered. Is it immediate children, spouses, grandparents, cousins, aunts? You know, the list can go on. Stepchildren. It's in whatever the employer wants. There's no law regarding requiring bereavement leave, much to many employees' dismay and disbelief. You are not required to give it. And then how much time off? A day, 1 day, 2 days, 3 days. I've seen as much as a week. Is proof of death required? Some employers want to see a death certificate. Some employers say, I don't want to do that during a time of what might be very difficult, because sometimes they're hard to get. If you're not part of the immediate family, it requires you to jump through some hoops with the county, at least here. So the bigger question, though, that comes up is it going to be paid or unpaid? I will tell you that most of my clients that we've prepared their handbooks and policies for them do have bereavement leave of some kind, and I have never had a case of anyone abusing it. I've had employers call saying, well, I think maybe so-and-so took 1 day off when they shouldn't have, but not an abusive policy where somebody was doing it all the time or took too many days, took all the days and they really didn't think they were entitled to any of the days. But it's up to you. And then the other is I would put under a big umbrella of personal leave for any reason. Many employers have policies allowing for personal leave for cosmetic surgery. A lot of people are getting cosmetic surgery these days. Personal leave for psychological counseling. Personal leave for counseling of children. I mean, it can be just about anything. Personal leave for medical condition that doesn't fall under one of the other leaves. And you have the same types of questions. Who's going to be entitled to it? For how long? Are we going to give them reinstatement rights? Is it going to affect their benefits? And the same thing with bereavement. You know, we always want to look at, is this going to affect, if your bereavement leave is long, is it going to change any accrual of vacation, anything like that? And then, of course, we want to make sure domestic partners now with the Supreme Court ruling are covered by these policies as well. So in addition to the federal, state, and local laws, you need to make sure you're in compliance with your own company policies. And that raises the issue of, do you put all of these policies into your handbook that we've gone over today? And there are two schools of thought on this. Many employers say to me, I don't want to list all of these potential leaves in the handbook because an employee is going to see this and may or may not be entitled, but is going to create that entitlement so that they can take the time off. And so I'm not going to do it. I'm not going to put them in. The other school of thought is most companies, especially smaller companies, are run by HR directors who may not be aware, even Linda and I weren't aware of a couple of these, of some of these policies. So there should be a place for them to go to that everybody's aware of and everybody has acknowledged reading and agreeing to, that they can jump to and say to the employee, oh, here's the policy on that. Here's the law on that. Here's what we have to do to make sure that we're compliant on it. And here's what you have to give to me, so that they know that they have that. Again, I always speak to the culture of a company. Not every company is the same. I represent small, private, very conservative private schools that have policies much different than the technology companies that I represent, where their workforce is, 18 to 30-year-olds. And so you need to talk to your attorney or your HR representative and determine what's the best policy for you, what works for your company. Some companies are very generous with their leave, and others are very tight. And that doesn't make one company better than the other. Penalties for noncompliance. As I said earlier, almost all of them prohibit discrimination, and that's why I call them more discrimination statutes than leave of absence statutes. And it's discrimination against employment practices is what I would say, but discharge, retaliation, removal of benefits, I'd say even removal of work schedules, change in work schedules, those types of things. The penalties can include reimbursement for lost wages and benefits. I pointed out a couple of the statutes that have that. Reinstatement, almost every one of them has that. Some of them do require that the employee go through an administrative process first before heading to the courts, but all of them do allow for civil actions. So those that require administrative process first, you have to do that before you could go to civil court, but several of them you could go straight to civil court. And that's where I complete my portion, and we open it up for questions.
Well, great. Thank you so much, Linda and Marla. I learned so much today. I always think I know some of these things, and that voting thing got me kind of, what? I didn't know that. So just really thank you so much for giving us part 2 of the leave of absences. That was really helpful. And that does conclude the presentation portion of our webinar, and now we'd like to turn that over and allow you to ask some questions. And again, going through that real quickly, there is a section over on the right-hand side of your screen that allows you to actually ask questions, submit questions, and I know our speakers both encouraged people to actually comment too if you have any situations that were mentioned in the webinar that you'd like to share with us. We'd certainly appreciate that as well. So I am going to start here with one of our questions. Hold on just a minute. Let me pull that up real quickly. And again, you can either use the question section or you can use the chat feature. We have a question here. Let's see. Who volunteered? Let's see. They have an employee here. Hold on. I cannot make that screen bigger. Just 1 second here. Okay. Let's see. My goodness, I don't know why it's not getting bigger here. Is there a law for those employees who have volunteered with the American Red Cross for catastrophic events? So again, we've had a lot of those going on in the country, and people who are volunteer, they're sometimes first responders, and they need to be called out by American Red Cross or some of our other emergency response volunteer type things. Is there a law that gives people some kind of leave if they volunteer for these types of events?
No, because it's a private organization.
Okay.
But
okay, good.
I'm sorry, Linda, go ahead.
No, I was going to say, not that I know. Of course, an employer could allow people to take a personal leave for whatever reasons they want, right? So
right.
You could, your own policy or do it on a case-by-case basis is what I would recommend. And then again, someone comes forward and you decide, yeah, I really like to support them in going to wherever to help out, give them a leave.
That was going to be my comment. You can always do more than what's required by law. And certainly a lot of employers are very community, are very driven to giving back to the communities that they're in, and would grant that type of leave. A lot of it depends, again, on whether it's reasonable, who's asking for leave, how much time do they need, can we live without them?
Okay, good. Thank you. And Robert has a question. Can the company make forms available for absentee voting? So rather than deal with those couple hours off or whatever, can we, try to encourage our employees to, rather than take the time off, to do an absentee ballot?
You can make them available, but you can't. I would not go so far as to encourage. This is one. The jury duty and the time off for voting are two statutes that have been around for a long, long time. Most of the others are new, as Linda pointed out. Some of them, they've been around for a long. That was just something from the beginning that employers were told you can't infringe on this. We need people to serve on juries, and we want people to vote. We want to encourage voting. And so we want to give them every opportunity to do so. Before the recent years, employers then had full discretion on what other type of time they gave off for leaves of absence. Obviously, that's changed. But because of that, because that's such a strong protection for the employee, I would not want you to encourage them to. Making them available is one thing. Look, we have them here if you want them. But if someone says, no, I really need to go, I need to be in that booth, I need to have that feeling, I wouldn't risk that.
Okay.
Again, it's such a small percentage. I mean, I don't know, Marla, have you had clients that have employees that can't vote during the regular, before or after the regular shift? I mean, this has never come up for me in any of the places where I've ever worked or any of my clients.
Yeah, I think we talked about it. I had one, and for some reason we did have to pay, we're talking over 15 years ago. I can't even remember who the client was. I just remember thinking, what? I have to give you 2 hours off and I have to pay? I remember thinking, and so it may have been when I was in-house counsel because of taking it so personally. that would have been 25 years ago.
Yeah, when the polls open at 7 a.m. and close at 8 p.m. in California, I mean, again, it's going to be really unusual. I mean, the person would have to be, like, sent on assignment someplace, like, oh, you live in Irvine, but today you need to work in Bakersfield or something. I mean, it'd have to be almost something like that unless there's an alternative work week involved or there's just an excessive amount of overtime.
Okay, good. And staying with that kind of voting topic, Kylie has a question. For time off to vote, will the state law posters satisfy the posting requirement, or do they need to have a separate posting for the 10-day time period?
Well, that is a state.
Yeah.
Go ahead, Marla.
Well, I think she's talking about the poster that's all inclusive, like the ones you can get from the Chamber of Commerce, that has it on there, and you just leave it up all year. That's fine.
Okay. Did you want to add anything, Linda?
No, make sure it's included on that. Make sure if you have one of those laminated posters, you can buy it from all sorts of different sources. Make sure that it's included in that. Most things are. I know one thing that's never included in that is the IWC posting, for your industry. So you want to make sure you always have that separate. And then if it's included in that, you're fine. What we used to do is literally you can just download something off of I don't even know what website it shows up on, but it goes out from everybody on the planet, a month ahead of time, and just print it out, throw it up in a few places where your employee posters are, and you're good to go.
Okay, well, and Linda, maybe you raised a point for a future webinar. Maybe we'll do a webinar on postings. But Linda's absolutely right. Yeah. Very rarely do I walk into an employer's office and they have the industrial wage order hanging, because it's hard to hang. It's several pages, but you still have to hang it.
Yeah.
Okay, that is a good topic for a webinar. Moving on, Gwen had a question whether the organ and bone marrow donation, is that a California state or federal law, and is that also covered under ADA?
It's California.
Yeah. And go ahead, Linda. Sorry.
Go ahead.
I was just going to say it depends. I mean, if the person becomes disabled under ADA, then yes, ADA would apply. So it's possible. And whoever asked that question brings up a good point that maybe Linda and I didn't hammer home enough. When you have any of these leaves, or some of these leaves, you might have interplay with the ones we spoke about before, with ADA in particular and FEHA and CFRA. So circumstances can start one way and change, or they may apply both at the same time.
Right, and I'm not sure what the linkage is for somebody between that and ADA. I mean, this is really so I find out that, you know, my brother needs a kidney or something like that, and I get tested on a match, and I decide that I want to donate a kidney, then I can go to my employer and say, hey, I need up to 30 days to donate an organ, right? So it doesn't have anything to do with ADA for me. I'm not disabled. I'm healthy. I'm giving him a kidney.
Well, but if you become disabled after you have the surgery.
Right. So if something happens and there's a complication and there's a medical condition that results or I become disabled, then yes, but I think that's sort of a stretch from my hopefully, you know, just stretch and nothing like that happens.
Okay. Okay, good. And KinCare, is that California state or federal?
California.
California.
California. Okay, good.
Did you get a response to my question, Julie?
I did not get a response yet, no.
Okay.
Okay, no examples here yet either. Let's see. And then we have Jennifer has a question regarding military leave. She's got a current employee who is a reservist. When military training is optional, not required, or when the employee can choose when they attend required training, can we request that the employee delay training?
That's a good question. Jennifer, could you email me that question and let me pull the statute and look?
Because okay, so Jennifer?
Yeah. And let me know how many employees you have.
Okay, and again, Marla's email is right there. It's Marla at MRJ, I always say CLA, C-L-A. Just so I remember, I got to remember that C in there, you know. So it's MRJCLAW.com. See, now I want to say .clum. So now
and
we're on. Oh, go ahead.
I just wanted to let Jennifer know I'm on my way out after this webinar for a convention, and I'll be back on Monday. I'll email you a response.
Okay, good. Oh, yep, she just emailed you. Thanks, Jennifer. And then Gwen had a question, too, here on drug and alcohol. If there's a reason they are having a performance problem, aren't they protected under ADA? So she's saying number 15 is a drug and alcohol problem. If there's a reason they're having performance problems, aren't they protected under ADA?
No, current drug and alcohol use is not protected.
Okay. Okay, good. It looks like, ladies, that is it for questions today. We're going to wrap up. I just want to thank everyone for attending. And again, thank you for our expert panel. We had Linda Duffy with Ethos Human Capital Solutions and also Marla Mehrab Robinson with Mehrab Robinson, Jackson, and Clarkson. Real quickly, again, both our speakers' emails are present right on the screen right now as well as in your handouts. We will also welcome any suggestions that you have for future webinar topics. Please feel free to email me directly, julie@enlightenedbiz.com, and we'd be happy to take those suggestions, or email one of the speakers. That would be fine, too. We're also going to be covering costly payroll mistakes for your next webinar in October. Please mark your calendars for October 17th at 11 a.m. And again, the registration link is right there, so go ahead and register right away so you make sure you reserve your spot. We appreciate your time today and look forward to providing you with more useful information in the future. Have a great day. Thank you.
Thanks, everybody.
Thanks.